Hi, my name is Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Maya Murphy has law offices in both New York and Connecticut, and Attorney MacDonald is admitted to practice in both New York and Connecticut. Attorney MacDonald will be discussing special education in Connecticut. So, Attorney MacDonald, what is a Section 504 plan and an individualized education program? How do they differ?
Hi, Hi, Emily. Thank you for asking. A Section 504 plan is a plan for how the school will provide support and remove barriers for a student with a disability. In order for a student to be eligible for a 504 plan, a student's disability must interfere with their ability to learn in the general education classroom. So a Section 504 plan can provide services and changes to the learning environment to enable a student to learn alongside their peers. For example, a support that could be included in a 504 plan could be a separate computer for a student with severe allergies so that they can still be in the same classroom with other students but have a safe computer and a safe location to work. While an IEP, or an individualized education program, is a plan for a child's special education experience at school. This plan is to provide individualized special education and services to meet a student's unique needs. An example of a support that could be found within an IEP is counseling or physical therapy to address a specific student's need. To qualify for an IEP, a student's disability must affect their educational performance and or their ability to learn and benefit from the general curriculum. So depending on the nature of your student's disability, they could qualify for both the 504 plan and an IEP. However, when your child's disability may not qualify them for an IEP, they still may be able to obtain a 504 plan, because under Section 504 of the Rehabilitation Act, the definition of disability is broader than what the definition of disability is for an IEP. Oftentimes I hear from parents and special education teachers alike that they want to explain during a PPT or planning and placement team meeting the specific supports and needs that a student is experiencing and needs. However, a teacher may fear retaliation or even losing their job if they bring up these certain supports that the school should be providing, because they're employed through the Board of Education, and the Board of Education may not have certain funds or resources to be able to provide those supports. So this, as a special education attorney and advocate, is very troubling to hear from parents and teachers that there are needs that disabled students have, and the school is not addressing them accordingly. However, I'm happy to report that Connecticut has recently instituted a law that says that no Board of Education shall discipline, retaliate, suspend, terminate, or punish any member of a PPT meeting that's employed by the Board of Education who discusses or makes recommendations concerning special education and related services for a child during that meeting. So going forward, if you're having issues during a PPT meeting in regards to teachers and special education advocates not accurately and appropriately making recommendations that they've told you that your child needs, you can bring this legislation to their attention to let them know that they don't have to fear any type of retaliation from the Board of Education, and that they're able to freely and openly advocate on behalf of children with disabilities. So if you have any questions about special education, PPT meetings, or your child's rights, please feel free to contact me. Thank you.